This is part two of the Chille DeCastro criminal trial in Nevada. I handle First Amendment cases, you guys know, and Second Amendment cases. The two statutes he's facing down, and this would go for anybody, I'm not just talking about him, they're sufficiently broad and vague that you can sweep innocent people into this. These invisible lines with statutes that say that, you obstruct, or the comments you made were exaggerated. See, that's a problem. What's worse, though, is that I've searched about 200 cases in Nevada to look into this, and I've got the case law. I want you to show you that, these statutes are constitutional. So let's take a look. I'm getting serious when I put my glasses on from Walmart. Hold on a second here. Okay, first up is this case from the Supreme Court of Nevada in 2015. And it deals with this situation. This was a statute, an ordinance that was deemed unconstitutional, and it had a lot of language similar to the one that Chille's being charged with. It's the section he's being charged with, obstruction 199.280. Our dissenting colleagues expressed concern that invalidating the ordinance will effectively invalidate similar provisions in our other Nevada municipalities. Concern is misplaced. The state could have charged Scott for his interference under 199.280, where it says it is a crime under the statute that Chille's facing when one willfully resists, delays, or obstructs a public officer in discharging or attempting to discharge any legal duty of his or her office. So the willfulness is what triggers its constitutionality as opposed to the other one, because it has to express an intent. They wrote 199.280 states it is a misdemeanor felony to willfully resist, delay, or obstruct. And they're saying, well, that language is very similar to what's contained in this ordinance. So, aren't you really saying that 199.280 is, well, no, it's not unconstitutional because the majority just said so. So this statute's constitutional. So any challenges that Chille is looking to make at trial that it's unconstitutional will lose. We have a recent decision that says it is constitutional. The sheriff's deputy arrested this passenger in the car, claiming he was obstructing an investigation of the driver who the deputy thought was under the influence, and said at 4:15 the vehicle had 3 occupants. William Scott, who was a passenger, interrupted the deputy, kept interrupting him. The deputy got tired of it because he said that it was obstructing his investigation, and this guy got convicted for interfering with the investigation by telling the guy not to answer questions. His dad's a lawyer. It says after the 3rd interruption, the deputy ordered Scott out of the vehicle. And then here he was charged with obstructing a public officer, similar to the statute that Chille's being charged with, but this statute was deemed unconstitutional. Heibel versus And here's the other one I want to show you, Heibel versus 6th Judicial District, 2002 case. Once again, Supreme Court in Nevada. They overturned the 9th Circuit on this case. And this was the predicate statute, Nevada Revised Statute 171.123. This is notorious for the sovereign citizens. We see this all the time, guys. It says, they say, hey, I don't have to give you ID. I haven't broken any law. You can't make me ID. And the reality is, yeah, they can. Look, a police officer has the right to detain you if they think that you're committing a crime, and they have a right to ask for an ID, and it doesn't abrogate the Bill of Rights. And then he said he wouldn't cooperate, but was willing to provide and unwilling to provide identification. Didn't believe he had done anything wrong. We always hear the soft sit saying that. I don't think Chille's a soft sit, but this is the argument. It's like, cop said, hey, I don't know who this guy was. I wasn't sure what was going on. I don't know. He was interfering with my investigation. So I put him in the car and charged him with 199.280. And he was becoming aggressive, moody. So that was enough to get this guy convicted. Okay. And then Kerry versus Nevada Gaming Control Board was a 9th Circuit decision. And here the High Court of Nevada was like, nah, we have a conflict with you. We don't think that you decided that right. We're deciding it for ourselves. Because Kerry would have said, no, the cop can't just ask for identification by itself. It says, because of conflicting authority, we believe an independent analysis of constitutionality is warranted. We conclude any intrusion on privacy is outweighed by the benefits to officers and community safety, knowing who it is. They talked about all the cops that got killed in the line of duty. That's dangerous in a traffic stop. The suspect's not required to provide private details about his background, but merely state his name to an officer when reasonable suspicion exists. And this is a corollary of Terry versus Ohio that I think Chille's always been talking about, trying to get return, that was his goal. It's ironic that this case is kind of a corollary. His case is kind of a corollary to this. Those two Nevada Supreme Court cases mention that the statutes he's being charged with are constitutional. This stuff has already been decided against him. That's why I'm saying these are difficult charges to beat, regardless of who you are. I don't like that, quite frankly. Nobody needs to have a statute that, like, there was a case I had against the Postal Inspection Service, and for a federal crime, it said that it had to be subject to the acceptance and approvals of the people within that local jurisdiction, which means this statute changes based on the geography of the country. So I filed an appeal and a challenge with the Postmaster General over in Virginia, and it became a 60-page opinion back on the constitutionality of this. I don't like these statutes because they are a threat to our liberty. You know, I'm just saying that the state has already made its decision. So the only thing, when Chille says he's taking it to the very end, once he files an appeal, because I personally think he'll be convicted of at least one of these charges. They may, you know, we'll have to see. I mean, he's presumed innocent, but I think he's going to get convicted. I think most people who get swept up in this would be convicted. Then he would have to file an appeal and, you know, take it from there. But that's a multi-year journey and costs a lot of money. So a lot of people don't have the staying power for that. One case I had on appeal because the other side kept appealing me because I kept beating them. I mean, 4.5 years worth of appeals. That's a lot of money. Let me know what you think.